I want you to hold on to that for the next few minutes. Everything I am about to tell you points back to that one thing. Every exhibit, every answer, every word I said from that bench. None of it brings it back. There were 3 moments in that courtroom when the room went completely quiet, not the small quiet between one lawyer speaking and another standing up. I mean the kind of quiet that settles when something true has entered the room and nobody knows what to do with it yet. I'm going to tell you about all 3 of them because that is the only honest way I know to tell this story now. Subscribe, not for me. For the reason I am telling this, some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. I did not begin with Dr. Daniel Mercer when this case first came to me. I began with Evelyn Parker. The file called her the complaining witness. The medical records called her an 81-year-old female with lower extremity pain. The charging document called her a vulnerable adult. All of those phrases were legally useful. None of them came close to saying who she was. The first time she entered my courtroom, she paused just inside the door and looked down at the floor before she took her next step. I noticed that because from the bench I see the delay before people arrange their faces. She used a cane in her left hand, and she moved with the care of someone who had learned that rooms ask for more from the body than they appear to ask. Later, while an attorney was speaking about scheduling, she folded a tissue in her lap into a tight square and then unfolded it again. I still remember that. Mercer was 47. He wore a charcoal suit, a silver watch, and the kind of expression that often appears on people who are used to being listened to before they have earned it in that room. I did not feel contempt for him. That would have made my job easier, and easy is not what the bench is for. I watched where his eyes went when he thought no one was counting. They went to the clock, to his lawyer, to the legal pad. They did not go to Evelyn unless she was saying something he thought might matter to him. There was one moment I found human in him. Evelyn was lowering herself into the witness chair, and before his lawyer touched his arm, Mercer half rose as if to help. He caught himself and sat back down. That stayed with me, not because it softened what I learned about him, because it meant care was still available to him. He had not lost the ability to see an elderly woman struggling to sit. He had simply failed to act when seeing her pain asked more of him than courtesy. What happened began, in the form the law could name, on Monday, March 4, 2024, at 10:40 a.m. in Exam Room 3 at Westfield Family Practice, 317 North Salem Avenue, Dayton, Ohio. Evelyn Parker came in complaining of pain in her right calf and foot. She said it burned when she walked to the mailbox. She said the foot felt colder than the other one. She said the pain woke her up at night. Mercer examined her briefly and sent her home with anti-inflammatory medication. In testimony, a medical assistant said Mercer looked at the chart and said, "At your age, pain moves around." He did not deny saying it. He said it again on the stand, only this time with a softer voice, as if the second version might somehow reach backward and improve the first. It did not. The pain did not move around. It stayed. It sharpened. She returned on April 12, 2024 at 3:18 p.m. She returned again on May 28, 2024 at 9:05 a.m. She returned again on June 17, 2024 at 2:14 p.m. By that point, her toes were pale. She could not sleep. A nurse wrote that the right foot was cool to the touch. Mercer still did not order urgent vascular imaging. He still did not send her to the emergency room. During testimony, he said, "I can't order a scan every time an older patient says, 'a leg hurts.'" That was one of the sentences that changed the air in the room, though not yet into silence. I did not need to tell anyone how to hear it. The people listening knew what it revealed. On July 3, 2024, at 11:52 p.m., Evelyn arrived at Miami Valley Hospital by ambulance. Acute limb ischemia, infection, no salvageable blood flow below the knee. At 7:32 on the morning of July 5th, surgeons amputated her right leg below the knee. I was not there for any of that. I learned it through records, photographs, testimony, and the strange grief of knowing something in full after the last moment to stop it has already passed. If something in what I have said so far has stayed in your chest, subscribe, because what I am about to tell you next will stay longer. Subscribe now and then let me keep going. When the case crossed my desk, it came in a thick brown file with a broken corner and 3 binder clips holding the medical records together. The paperwork looked ordinary. That mattered. Harm often enters the legal system wearing ordinary clothes. Intake sheets, coded diagnoses, copied prescriptions, a note that says follow up as needed. One of the hardest parts of this work is seeing how little language the law has for what a person actually loses. There's a detail most people outside a courtroom do not know about medical record cases. The chart is not just the note you see printed on the page. There is also an audit trail. That is the system's memory. It shows when a note was opened, when it was changed, and when it was finally signed. In plain language, it tells you whether the record was made at the time care was given or later after the outcome had become harder to defend. One of those audit pages made me stop. On July 4th, after Evelyn had already been admitted to the hospital, Mercer reopened the June 17th note at 12:08 a.m. The original line, right foot cool, severe pain, cannot sleep, was shortened in the final version to intermittent discomfort. That change did not take her leg, but it told me something about what he understood by then and what he was trying to protect. The charge sheet called it reckless neglect of a vulnerable adult causing serious bodily injury and falsification of medical records. That is how the law had to say it. But I remember looking at those words and thinking how thin they were against what the case had actually become. The law could name the offense. It could not name the bathroom Evelyn now needed help entering. It could not name the distance between her bed and the front door after surgery. It could not name the night she would wake up reaching for a leg that was no longer there. From the bench, courtroom entrances tell me things even before a witness is sworn. I see where people look before they remember to compose themselves. On the first morning of trial, Evelyn entered with her daughter Claire beside her and a tote bag hanging from the walker. She did not look at Mercer. She looked at the witness stand. Then she looked at the space beside it, measuring how she would turn. Claire kept one hand on the walker and one hand curled around the strap of that bag so tightly that her knuckles paled. Mercer came in through the side door with counsel. The gallery saw a physician in a neat suit. What I saw was his left heel tapping the chair rung before he sat, fast, regular. He glanced once across the room, not at Evelyn's face, at the prosthetic under her pant leg. Then he set his legal pad square to the edge of the table and waited. Silence 1 came on the second day of trial, just after 10 a.m., when Evelyn took the stand. She answered the first questions in a steady voice. Name, age, address. Then the prosecutor asked why she kept going back to the same doctor when the pain kept getting worse. Evelyn looked straight ahead and said, I kept thinking if I said it calmly enough, maybe he would hear me. The room stopped for 4 seconds. I know because my hand was resting on the docket sheet and I counted the beats without meaning to. That first silence was not sharp. It had softness in it, not comfort. Just the quiet that comes when a sentence is too plain to be argued with. The prosecutor lowered her eyes. Claire stared at the table. Mercer looked down, but not in shame. It was the look of a man still trying to rearrange the math. After silence 1, the evidence settled differently in my mind. This was no longer a case about one misdiagnosis. It was a case about repetition. Pain reported more than once. Fear brought back to the same room more than once. The same truth spoken until it should have become impossible to miss, and still it was treated as background. The first wave of evidence was basic but steady. Exhibit 14 was a portal message sent by Evelyn on May 29, 2024 at 7:12 a.m. It said, My foot is cold and I could not sleep last night. No answer for 4 days. Exhibit 19 was a pharmacy printout showing her anti-inflammatory medication had been increased after the April visit. No vascular referral. Exhibit 23 was an emergency room photo of the right foot beside the left, pale and mottled in a way I have not forgotten. Then came Anita Flores, the clinic nurse. She said Evelyn cried when she removed her shoe on June 17th. She said the foot was cool. She said the pulse was hard to find. On cross-examination, when defense counsel tried to soften the certainty of what she had seen, Anita said, she apologized every time she asked for help. I wrote that sentence down in my own hand, not because it was dramatic, because it told me how small Evelyn had been made to feel inside her own pain. Subscribe before I go further. I have more to tell, and the more I tell, the more it matters that someone is listening. Subscribe and turn on notifications, then let me continue. The defense did what a defense is supposed to do. They slowed the case down and reminded me that medicine is not math. They brought in a vascular specialist who said even early imaging in March might not have guaranteed full limb salvage because Evelyn had diabetes and long-standing artery disease. That mattered to me. Courts are not built to punish every bad outcome. We are supposed to measure decisions, not sorrow alone. For a while, that gave me real pause. If this had been March only, one visit only, one uncertain symptom only, the case might have remained in another category. But it was not March only. It was March, then April, then May, then June. It was the portal message. It was the altered note after the hospital admission. It was the same distress returning to the same physician until delay itself became part of the injury. There is a limit to what I can do from the bench, and it has never once included undoing what already happened. In the middle of that trial, during a recess, a memory from my own life returned so clearly I could almost hear it. I was 12. My grandmother stood at her stove in a blue house dress, one hand on the counter, one hand rubbing her shin through her stocking while beans simmered under a rattling lid. She did not say she was hurting. She shifted her weight, stirred the pot, and looked out the window over the sink. Sun lit the dust above the kitchen table. I remember the clock ticking louder than usual. Then the bailiff opened the courtroom door and I was back on the bench. Mercer took the stand that afternoon. He spoke in a quiet, controlled voice. He said, "I thought she was exaggerating from fear." That was the quiet quote, and it was still wrong. Then he said, "I had 52 patients scheduled that week, and I was doing the best I could." He meant it as context. I heard it as permission he had granted himself. Later, trying to sound more human, he said, "I never wanted Mrs. Parker to lose her leg, but if I sent every senior with leg pain for urgent testing, the system would fall apart." I wrote that one down and looked at it for a long time before I moved on to the next page. He thought he was talking about resources. What he told me instead was where he had decided the cost should land. Silence. 2 came at the end of his testimony, a little after 3:40 p.m. Defense counsel asked if there was anything else he wanted the court to understand. Mercer sat still and said, "I did not think she would pay this much for waiting." Then he stopped. That silence was different from the first one. Silence 1 had softness. Silence 2 had edges. Nobody shifted papers. The court reporter's hands hovered for a beat over the keys before dropping back down. It lasted perhaps 3 seconds, but it felt tighter than the first, narrower, as if the room had just seen the final shape of the truth. After that sentence, I understood that waiting to him had always been a cost. He had simply believed the cost belonged to her. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. By the time closing arguments ended, the room felt smaller in the way courtrooms sometimes do when the moral distance between 2 tables becomes plain. The prosecutor said this was not one bad medical call. She said it was a pattern of choosing not to hear an older woman unless her suffering arrived in a form dramatic enough to interrupt his routine. Defense counsel said criminal law should not be used to punish medical imperfection. That was fair to say. I considered it seriously. I rejected it carefully. When I returned to the bench with my ruling, I had made the decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. I found Daniel Mercer guilty of reckless neglect of a vulnerable adult causing serious bodily injury. I found him guilty of falsification of medical records. I said each count slowly. After the verdict, Claire closed her eyes and lowered her head once. That was all. Evelyn turned slightly toward her and said very softly, "You can stop holding your breath now." I have said that sentence back to myself more than once since the case closed. I have not told you what I ordered yet. I am about to. Subscribe before I do. Not because it is dramatic, but because I want to explain every part of it, and I want you to be here for the explanation. Subscribe now. At sentencing on March 11, 2025, I began with custody. I said, I am ordering you to serve 24 months in state custody, followed by 3 years of supervised probation. I said it because this was not a paperwork failure. You did not merely overlook one symptom on one crowded day. You ignored repeated warnings and then altered the record after the damage was already done. The sentence had to say that plainly. Then I turned to restitution. I said, I am ordering restitution in the amount of $486,000 to Evelyn Parker. I explained the number: prosthetic fitting and replacement, physical therapy, home modifications, transport, in-home care. Injury enters a person's life one doorway at a time. If the court was going to name the cost, I wanted it named in the places she would actually live with it. I also imposed a fine. I said, I am ordering a fine of $200,000 to be paid into the Montgomery County Elder Pain Access Fund. That fund supports urgent screening and transport for low-income seniors with vascular complaints. Money cannot restore what he took. But if it was going to leave his hands, it would go to the exact point of failure in this case, the space between pain reported and pain believed. Then I addressed his license. I said, you are prohibited from practicing medicine in this state for 5 years, and this judgment will be forwarded to the Ohio State Medical Board. I explained why. A license is not only permission, it is access to another person's fear, pain, and private trust. For 5 years, he would not examine patients, sign charts, supervise residents, or stand in a room where another person had to decide whether he meant them well. I was not finished. I said, I am also ordering 1,200 hours of community service at the Dayton Mobility and Geriatric Pain Center. Not generic service, not hours detached from the harm. He would assist with patient transport, intake support, and non-clinical chart preparation for elderly patients waiting on mobility and vascular care. I ordered that because I wanted his time spent beside the exact kind of suffering he had trained himself to treat as background. Then I gave the order that changed his face for the first time. I said, within 30 days of your release, you will stand in the main auditorium of Westfield Family Practice before staff, residents, nurses, patient advocates, and senior patients, and you will read aloud a written statement of responsibility no shorter than 1,000 words. I required it to be spoken, copied, and distributed. Quiet harm survives in rooms where people keep calling routine by its old name. I wanted that room altered. And there was one more thing. I said, you will fund 3 years of counseling and peer support for Evelyn Parker, 1 year of caregiver support for Claire Parker, and a replacement mobility scooter if her treating therapist recommends one. I ordered that because restorative terms should answer the injured person's actual life, not what is easiest for the court to count, what is needed. Then I spoke to him directly. I said, Dr. Mercer, you did not merely miss a symptom. You heard the same pain more than once and treated its repetition as inconvenience. That choice cost Evelyn Parker part of her body, part of her sleep, and part of the ordinary privacy of moving through a day without planning every step. I looked toward his family and said, to those who love you and did not choose this conduct, I offer neither accusation nor comfort the law cannot honestly give. Then I looked back at him. Your position required curiosity, patience, and care. You chose speed, assumption, and distance instead. Evelyn Parker came to your office for help. She should have left it with help. That was silence 3 in full. After the last sentence, the room went still in a physical way. My sleeve rested against the wood of the bench, and I could feel the grain through the robe because I had gone that still. Claire's hand stayed on the handles of her mother's chair. Mercer stared forward. Evelyn did not move for 2 or 3 seconds. When the silence broke, it broke with one careful breath taken through her nose, as if she had decided breathing was still worth doing in that room. There are other people I want to speak for. Other cases where someone needed a voice in that room and what they received instead was procedure. Subscribe and I will tell you those stories when I am ready to tell them. This was the first one I was ready for. I stayed on the bench while the courtroom emptied. Claire leaned down beside her mother, touched the back of her hand, and said, "Mom, we can leave now." She did not say we won. She did not say it is over. She said we can leave now. Then she turned the chair toward the aisle and stopped once so Evelyn could straighten the blanket over her prosthetic. Mercer appealed. The Ohio 2nd District Court of Appeals heard the case. On May 19, 2026, that court affirmed the convictions and all major terms of the sentence, sending the case back only for a minor correction to one probation reporting deadline. In plain language, the appellate ruling said the record showed repeated disregard, altered documentation, and enough evidence for the trial court to treat the conduct as criminal. The appeal process took 14 months. When I read the opinion, I put both hands flat on the paper and let the room stay quiet. There was one thing I learned later that has remained with me. On October 14, 2025, during a compliance review tied to his probation, I was told Mercer had finished a shift at the Dayton Mobility and Geriatric Pain Center. A transport aide was late. An older woman named Mrs. Alvarez was waiting outside imaging with her folder in her lap. Mercer stayed with her for 23 minutes and pushed her himself when the hallway cleared. A staff note said she thanked him, and he said, "Take your time. I'm not in a hurry. I'm telling you only what I learned. You may do with it what you think is fair." The question this case left me with is not whether one doctor can fail one patient. I know the answer to that. The question is how many calm ways a person has to say, "I am in pain," before disbelief becomes a choice rather than an oversight. I still turn that over. Harm does not always arrive with raised voices. Sometimes it arrives in routine language, in a short appointment, in a delayed message, in a note changed after midnight. If you have been where Evelyn was, then you know the feeling I recognized in her face before she ever spoke. It is the carefulness of someone trying not to ask for too much while asking for something that should never require begging. It is the look of a person measuring every word so they will not be dismissed for sounding tired, afraid, old, or inconvenient. I recognize that look. When it entered my courtroom, I treated it as evidence of effort. And if you hold the kind of job Mercer held, if people place trust in your hands because your title tells them to, then here is the question I wanted to ask him from the bench but could not because it was not a legal question. When did efficiency become more valuable to you than curiosity? That is the question. Here is the one thing I will offer with it. The next time an older person tells you something hurts, sit down before you answer. The sentence could not give Evelyn Parker back her right leg. That was true when I spoke it. It is true now. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you leave a comment, leave the kind that makes this space feel less like a feed and more like a room where people who still know how to listen find each other.